Hi class, today we will be moving on to part 2 of summary trial procedure. In this chapter we will be discussing the provisions related to summary trials and high court trials, as well as other ancillary provisions related to summary trials and high court trials. Right, in part 1 we have already discussed the main provisions regarding summary trial procedure, which is located in section 173 of the CPC. Now, what are the other important provisions in regards to summary trial procedure and high court trials? Firstly, what happens at the end of trial? So we look at section 173 subsection M and section 182A of the CPC, which provides that at the conclusion of the trial, the court shall consider all evidence and shall decide whether the prosecution has proved its case beyond all reasonable doubt. So the burden of proof in criminal proceedings is beyond reasonable doubt. Now this is different than civil proceedings, which is on a balance of probabilities. So the prosecution's job is to prove its case beyond all reasonable doubt. Now the distinction is it's not to prove the case beyond an unreasonable doubt. It is only a reasonable doubt. So what is a reasonable doubt is a question for the judge to decide. And the burden of proof is provided in section 101 and section 102 of the Evidence Act 1950. It is also provided in cases such as Yuvaraj and Muhammad Radi bin Yaqub. Now, the accused is always presumed innocent until proven guilty, and therefore the accused only bears an evidential burden, only to raise an issue of fact. It is not the accused's responsibility to prove that he is innocent. Now, however, if the accused wishes to raise certain defenses, like for instance, if he has an alibi, or he wants to raise defense of insanity or provocation, then he has the legal burden and not just an evidential burden to prove its case on a balance of probabilities. Now, balance of probabilities is a lesser burden of proof than beyond reasonable doubt. And this is what the accused has to establish in order to prove his defenses. And this is held in the cases of Yuvaraj and as Miller against Minister of Pensions. Now, the burden of proof on the accused for defense of alibi is provided in section 103 of the Evidence Act 1950. Also look at the illustration B. And for defense of insanity or provocation, it is provided for in section 105 of the Evidence Act 1950. Now, the two-stage test of beyond reasonable doubt was established in cases of Mat, and as well it was approved in the case of Muhammad Radi bin Yaqub. Firstly, the first limb is that if the accused's explanation is accepted, the magistrate or trial judge must acquit the accused. And then it goes to the second stage, which is if the accused's explanation is not accepted, the magistrate may still acquit the accused if there is doubt of the accused's guilt. Now here we must note that the doubt here must be a reasonable doubt. Now let's look at the case of Aulia Sheikh Awayal against public prosecutor. In this case, the accused person was convicted of murder of two persons and as well as attempted murder of another person, which was based on circumstantial evidence. The Court of Appeal dismissed the accused's appeal. However, the federal court allowed his appeal on the following grounds. Firstly, although the appellant explained that he used the red gloves as his DNA was found on the gloves, the High Court failed to consider whether the prosecution had proved its case beyond reasonable doubt. Now, with regard to the offence of attempted murder, the High Court failed to carry out a maximum evaluation of the evidence of the victim, as the doctor was not called to elaborate on the injuries. Therefore, it was unsafe to convict the appellant for the offence of attempted murder. So therefore, we must understand that the prosecution is the one that has the legal burden to prove its case. Even though the accused may volunteer some information, that does not constitute proving its case beyond a reasonable doubt. So therefore, the High Court had used the wrong standard of proof by requiring the appellant to prove he was innocent, and for the prosecution to prove the appellant's guilt only on a balance of probabilities. Now, since there was no exceptional circumstances, the court could not rely on the proviso to Section 92, subsection 1 of the Courts of Judicature Act to affirm the conviction and sentence by the High Court and the Court of Appeal. Now, let's look at an important aspect of trials, which are the witnesses, and more specifically, how the witness gives his evidence, how he is examined and cross-examined and re-examined. Now, before any witness gives evidence, you will see that the court will instruct him to take an oath or affirmation, which may contain the following words: I do solemnly swear or affirm that the evidence which I shall give in this case shall be the truth, the whole truth, and nothing but the truth. So this is the oath or affirmation that the witness will take before he gives evidence. Now, the witness has the right to choose the language in which he wants to give evidence, and an interpreter will be provided if it is required. Now, we must note that a witness may also give unsworn evidence, and when he gives unsworn evidence, the weight to that evidence becomes suspect and is generally lesser than giving evidence on sworn evidence. Now, each witness for the prosecution or defense shall undergo examination in chief, cross-examination, and re-examination. And this is provided in Section 138 of the Evidence Act 1950. Now, in the first stage, which is the examination in chief, the purpose, the aim, the object of examination in chief is for the witness to give his evidence of the facts in issue or relevant facts, and he gives evidence for the party that calls him. So let's say it's the plaintiff that calls the witness or the prosecution that calls the witness. Then the prosecution will conduct the examination in chief. Now, nowadays, examination in chief may also be conducted by providing a written statement by the witness. This is done in order to save time, and also it will reduce costs in practice. Now, for an effective examination in chief, the witness should give the evidence on his own words with minimum prompting and must be confident and honest. The witness should not give evidence in the words of his counsel, and leading questions are not allowed. So what are leading questions? Leading questions are basically when the counsel or the person conducting the examination leads the witness to a certain answer that he wishes to acquire. Now, for example, if the question is that whether the accused hide hid the knife when he stabbed the victim in the closet? Now, this is a leading question. Leading questions will often indicate what the answer that the party wishes to acquire. Now, a non-leading question would be simply asking the witness, what did you see? This is an open-ended question and does not lead the witness to a particular answer. Now, if the witness turns hostile, for example, when the witness gives evidence against the party that calls him, he has to be impeached by the party that calls him. And when impeachment is done, leading questions can be asked. Now, the second stage is the cross-examination stage. Now, cross-examination of a witness is done by the adverse party. For example, if the prosecution calls a witness, the prosecution will conduct the examination in chief, and the accused or defense counsel will conduct the cross-examination of the witness. Now, the object of cross-examination is to rebut or create a doubt of the evidence of the witness who has given his evidence in the examination in chief. Now, the witness must be cross-examined as to the material facts so as to weaken the case of the prosecution or the defense, so as to create a doubt as to material facts and material evidence given by the witness. Now, the last stage is the re-examination stage. Now, here the witness who has been cross-examined will, if necessary, undergo re-examination by the party that calls it. Now, for example, if the prosecution is the one that calls the witness, he will also be the one to do the re-examination. Now, the purpose of re-examination is to repair any damage or unclarity that has been caused by the cross-examination. Counsel here is allowed to ask questions to explain matters that have been raised during cross-examination. Counsel is not allowed to raise new issues or new questions or ask any leading questions during the re-examination stage. Now, there may also be times where counsel will raise objections to evidence. Now, when evidence is given by a witness, the other party may object if there are leading questions, and the counsel is not supposed to ask leading questions at that stage. Counsel may also object if the evidence is irrelevant, or it is hearsay evidence, similar fact evidence. All these are inadmissible evidence. Or if the witness is an incompetent witness or should not be compelled to answer a question. These are all examples when counsel may raise an objection. Now, the court must hear the reasons for the objection, and then the court will decide whether the objection is sustained, meaning the objection is allowed, or the objection is overruled. Now, the party who objects should see that his objection is recorded by the court so that it may be used in his appeal if needed. Now, next we look at calling prosecution witnesses. The prosecution can call any prosecution witness and the court will not interfere. This was held in the cases of Adel Muhammad El-Dabar and Muharram B. Anson. Now, the sequences of the prosecution witnesses. How should the prosecution call their witnesses? What sequence should they be called in? the prosecution has to plan out the sequence of calling the prosecution witnesses so that all the evidence will be coherent and done so in a logical manner. This is because it needs to be done this way so that a prima facie case will be made out clearly for the judge. Now, the prosecution witnesses are usually termed as PW1, PW2, which means prosecution witness 1, prosecution witness 2, and so forth, until the last prosecution witness is called and the prosecution's case is closed. Now, the prosecution has to make certain that any material prosecution witness is called, otherwise an adverse inference may be made against the non-calling of that witness. And this is provided for in section 114 subsection G of the Evidence Act 1950. Now, in section 173 subsection C and subsection D, as well as section 179 subsection 2 of the CPC, it provides that a prosecution witness shall undergo examination in chief, cross-examination and re-examination. If a prosecution witness is not called to give evidence, it must be brought to the attention of the court and made available to the defense. And this was held in the case of Teh Li Tong. Now, it may be fatal to the prosecution's case if a witness is not called and an adverse inference can be made under section 114G of the Evidence Act 1950. Now, let's look at the case of Abdullah Zawawi. The court held that it is the prosecution's right not to call a witness, but if this results in a serious gap in the prosecution's case, it may be fatal to the prosecution's case, and an adverse inference may be made under section 114 subsection G of the Evidence Act. Now, even though that witness is offered to the defense, this is not sufficient to close the gap, because it is not the defense duty to prove a prima facie case. Now, next we look at the case of Teo Ho Chai. The appellants in this case appealed against their conviction for drug offences on the ground, amongst others, that the prosecution failed to call the witness to identify the exhibits. Now, the Supreme Court held that the matter in issue was not whether or not the investigating officer had been called to give evidence, but whether there was a serious gap in the chain of evidence in the prosecution's case. In this case, the court held that there was a serious gap in the chain of evidence as the prosecution failed to call the witness to identify the exhibit. Therefore, the appeal was allowed. Now, in the case of Muhammad Osman B. Pawan, in a drug trafficking case, the customs officer who counted the exhibits was not called to give evidence. However, he was offered to the defense. Now, the court held that this was a serious gap, as the evidence of the customs officer was crucial. And although it was offered to the defense, this was not sufficient to close the gap. As well, we look at the case of Abdul Jalil B. Abdul Sattar. Here, the retired police officer was not called to identify the exhibits. Here too was held to be a serious gap in the prosecution's case. Next, in the case of Abdullah B. Yaqub, the police officer who had custody of the ganja was not called to give evidence. Here as well, the court held that this was a serious gap in the prosecution's case. Similarly, in the case of T. Chu Hyang, the agent provocateur was not called to give evidence, and the court held that this was a serious gap in the prosecution's case. Now contrast this with the case of Abdul Latif bin Sakimin. The court held that the non-production of 3 witnesses did not create a reasonable doubt that the accused was not in possession of the dangerous drugs. Now the court here decided that there was enough evidence other than the 3 witnesses to establish a prima facie case against the accused, even though the 3 witnesses were not called. Now lastly, we look at the case of Adis Waran Taruma Putrinta. The accused appealed against his conviction for murder on the ground, amongst others, that by not calling a witness who was the first accused sisters, it was fatal to the prosecution's case. The federal court dismissed the appeal of the first accused and held that Section 114G was not applicable, and there was other sufficient evidence to prove the case of the prosecution. Now, therefore, we can conclude that non-production of a witness may or may not cause a serious gap in the prosecution's case. It depends on the facts of the case and on the witness himself, whether the witness is able to provide material evidence in the case. Next, we look at the law regarding demeanor of witnesses. Now, Black's Law Dictionary defines demeanor as facial expressions, tone of voice, gestures, and the hesitation or readiness to answer questions. Now, in Section 271 of the CPC, it provides that the magistrate may record the demeanor of a witness at the end of his evidence and at the foot of the notes of the court, judge's notes. Now, in the case of Lau To Cheng, it provides that the accused magistrate has to give reasons if he disbelieves a witness. Next, in the case of Tara Singh, it provides that the accused magistrate should only remark on the demeanor of a witness at the end of his evidence. Now, in the case of Tengku Mahmud, Raja Aslan Shah, as he then was, provides that demeanor is not always the truth, but only one of the ingredients for the credibility of a witness. Also, in the case of David Anthony, the court provided that demeanor was written at the footnote, but no remarks were recorded. Therefore, a retrial was ordered. Also, in the case of Abdul Latif bin Sakimin, the court was satisfied that the witnesses were telling the truth and were credible witnesses after scrutinizing their examination in chief, their cross-examination and re-examination. Now, in Ramanathan Anak Lelaki Celia, the court held that the court has discretion to record the demeanor of the witness under Section 271 of the CPC. Now next, in Section 173 subsection J subsection 3 of the CPC, it provides that where an accused is called to enter his defense, he may produce evidence. Now this is when the accused, if he has an alibi or other defense, he must adduce that evidence at this stage. But we must note that if his defense is of an alibi, notice of alibi must be given beforehand, and this is provided in Section 402A of the CPC. Now, when the accused is charged the court shall inform the accused of his right to a defense of alibi. And if the accused intends to raise a defense of alibi, he shall give a notice of alibi during the case management process. Now, if the accused has not given notice of his alibi during case management process, he may adduce evidence in support of an alibi at any time during trial if he has given written notice to the public prosecutor, who then is given reasonable time to investigate the alibi by the accused. Now, the notice of alibi shall include the particulars of the defense of alibi, for example, the place where the accused was, or if the accused is an alibi witness. The notice of defense of alibi must be signed by the accused or his counsel, as the notice is then to enable the public prosecutor to check on the truth of the defense of alibi. And this was held in the case of Krishnan in 1981. Now, contrast this with a bare denial, which is admissible in evidence without notice. This was held in the case of Vasant Singh. The accused claimed he was sleeping and was not at the scene of the riot, and this was held to be just a bare denial. Okay, there are two crucial points that we must note about alibi defense. When someone is arrested and in his caution statement to the police he gives an alibi, does that count as a notice of alibi? The answer is no, as a statement of alibi in a caution statement is not notice to the public prosecutor as required under section 402A of the CPC. This was held in the case of Hussein B. Silit. Now, furthermore, non-compliance with section 402A of the CPC will render the evidence of alibi not admissible, and this was held in the case of Rangapula and the case of Kulipsi. So, it is crucial that notice must be given to the public prosecutor beforehand if the defense wants to rely on the defense of alibi. Now, in the case of Lim Chen Lin, the court held that a notice of defense of alibi is mandatory, and if not given, the evidence of alibi is not admissible. Secondly, in the case of Duis Akim, the Court of Appeal overturned the decision of the High Court which acquitted the appellants of murder, as the High Court gave emphasis on the defense of alibi and doubted the identities of the assailants. The Federal Court, when dismissing the appeals of the appellants and affirming their convictions and sentences of the Court of Appeal, held that the witness had positively identified the accused persons and this took precedence over the defense of alibi. Now, also in the case of Ahmad Rashidi Zainul, this was a robbery case, and the court held that their defense of alibi was only a recent innovation and therefore a mere afterthought, as it was created recently, and they were therefore convicted of the crime. Next, we look at the case of Public Prosecutor against Azila Adri. The respondents were jointly charged in the High Court for the murder of Altantuya under Section 302 of the Penal Code, read together with Section 34 of the Penal Code. Now, to support the accused's defense of alibi, the entry in the station diary was tendered to show that the first respondent was actually elsewhere and not at the scene of the crime. Now, having found that the first defendant's plea of alibi was unproved, whilst the second respondent's unsworn evidence was ineffective, the respondents were convicted for murder and sentenced to death. Now, on appeal, the Court of Appeal quashed the respondents' convictions and acquitted and discharged them, basing that on their defense of alibi. The Federal Court allowed the appeal by the prosecution and affirmed the decision of the High Court, and held that an accused person has the burden to establish the defense of alibi, and a mere service of notice of alibi on the prosecution was insufficient to substantiate the truth of such notice. Now, the prosecution witness which confirmed the entry in the station diary was not called to court to establish the entry itself. Now, since there was a failure to call the maker of the statement, the first respondent's defense was a mere denial. The call logs from the first respondent's mobile phone established that the first respondent had made calls from the scene of the crime. The admissibility and the truth of the call logs established that the first respondent had lied about the alibi defense. As such, the defense of alibi was unsustainable. Next, we look at proof by written statement provided in section 402B of the CPC. Now, a written statement by any person shall, subject to subsection 2, be admissible as evidence as oral evidence. A statement may be tendered in evidence under subsection 1 if, firstly, the statement purports to be signed by the person who made it. Secondly, if the statement declares a declaration by that person to the effect that it is true to the best of his knowledge and belief. And thirdly, a copy of the statement is served by or on behalf of the statement party proposing to tender it on each of the parties to the proceedings not later than 14 days before the commencement of the trial, unless the parties agree otherwise. Now, whether the written statement must be agreed by both parties was considered in the case of Kingsley Obidyte against public prosecutor. Now, this was a drug trafficking case where the appellant appealed on the ground inter alia that before a witness statement could be produced, the appellant must agree to the production of the witness statement. And this is provided under section 172A, subsection 5, and section 172B, subsection 2, subsection 4 and 6 of the CPC. The Court of Appeal said that section 402B is similar with section 172A and 172B of the CPC. These are related to pre-trial conference and case management. Therefore, the court held that they should be read together, and section 402B, which stipulates that evidence may be proved by written statement which requires the consent of both parties, are read together with these other sections. Now, also note that section 402C, subsection 1 of the CPC, provides that evidence of any fact may be proved by a formal admission of any party. Now next, what about evidence of a person that was not called as a witness? Now, in section 396 of the CPC, it provides that if a person cannot attend to give evidence, the public prosecutor may orally apply to the court to produce him before the court to record his evidence on oath, and the court shall then issue a summons or an order for the attendance of that person. The court shall record the evidence of the person within 7 days from the date on which he was produced. Now, whilst recording the evidence, the person shall be examined according to the Evidence Act 1950, and the court shall cause the evidence to be reduced into writing. Now, the evidence recorded shall be admissible in evidence, and the weight to be attached shall be the same as that of a witness who appears and gives evidence at a proceeding. Now, next we look at the recalling of witnesses by the accused in a subordinate court. Now, in section 173 subsection J subsection 3 of the CPC, if an accused is called to enter his defense, he may produce his evidence and shall be allowed to recall and cross-examine any witness present in the court's premises. Section 173 subsection L of the CPC, the accused may apply to the court for any witness, document or thing to be produced, and the court may require reasonable expenses for the witnesses to be deposited in court. Now, what about recalling of witnesses by the prosecution or the accused in the High Court or subordinate court? Section 425 of the CPC provides that any court may summon any person as a witness or examine any person in attendance, though not a witness, or recall and re-examine any witness. And the court shall summon and examine or recall and re-examine any such person if his evidence appears essential for the just decision of the case. Now, the recalling of a prosecution witness must be done before the close of the prosecution's case, and this was held in the case of Yap Kok Meng. Now, does the prosecution witness, or can the prosecution witness be recalled after the close of the prosecution's case? Now, we have to look at a few cases to figure out whether this can be done. Firstly, in the case of Ki Seng Ni, the magistrate cannot recall any prosecution witness at the end of the defense case. And in the case of Lok Po Siang, section 425 only allows the prosecution witness to be recalled after the prosecution's case to correct any omission in the evidence of the prosecution. Lastly, in the case of Yap Kok Meng, before the end of the prosecution's case, the Sessions Court President refused the application of the prosecution to recall the prosecution witness. The High Court held that the prosecution's refusal was not justified. Now, in the case of Ramli B. Kacik, the Supreme Court held that there are two limbs to consider. The first limb, the court has the discretion to recall a witness, and the second limb is the court has a duty to recall the witness if the evidence is essential to the just decision of the case. So these are the two limbs for the court to consider when deciding whether to recall a witness. Now, in the case of Pon Nam, the High Court refused to allow the prosecution to recall the prosecution witness after the prosecution's case. The Supreme Court allowed the prosecution's appeal to call the prosecution witness and ordered a retrial. Lastly, in the case of Abdul Rahim B. Abdul Sattar, the police officer who prepared the list was not called to give evidence. However, later on, the trial judge recalled him under section 425 of the CPC. Now, recalling a witness after the charge is altered is provided for in section 162 of the CPC. Now, this section was considered in the case of Chok Mong Hu. Here the accused was charged for criminal breach of trust under section 408 of the Penal Code. At the end of the prosecution's case, the magistrate amended the charge, and the magistrate again amended the charge at the end of the defence's case and allowed the accused to recall any witnesses for the defense, but not for the prosecution. The High Court held that the magistrate had erred when he said only defense witnesses could be recalled. Now, the court may question the accused, and this is provided for in section 256 of the CPC. It provides that the court may question the accused to explain any circumstances. The accused shall not be sworn and shall not be liable to punishment if he refuses to answer or if he gives false answers, but the court may draw inferences as it thinks just. The accused's answers may also be evidence for and against him in any other trial for any other offence. The examination of the accused is for him to explain any circumstances and is not a general examination. The questions that are put to the accused are not to induce the accused to make incriminatory statements. The questions are only to explain facts disclosed in evidence against the accused. The questions and answers shall be recorded in full in the national language in West Malaysia and in English in Sabah and Sarawak. This shall be shown to the accused and explained to him, who is then given an opportunity to further explain or make addition to his answers. When the accused declares the record to be true, the record shall be signed by the magistrate. Now, the purpose of these questions is to clarify doubtful issues in order to assist the trial judge to make a just decision. Now, whether the trial judge had exceeded his powers. This was considered in the case of Gan Kok Leong, where the Session Court judge cross-examined the accused. It was held that the judge did not exceed his powers. Now, in the case of Lim Ching Po, the court frequently interrupted the examination of the accused. It was held that there was no evidence that the court sided with the prosecution, and therefore the trial judge had not exceeded his powers. Next, in the case of Teng Bun Hao, the court held that the trial judge had descended into the arena by the cross-examination of the accused, which was the role of the prosecution. Therefore, in this case, the court had exceeded his powers. Now, we have to note that Section 165 of the Evidence Act provides that the court has the power to question witnesses. Now, Section 265A of the CPC provides that, notwithstanding Section 264, at any time during any trial where any witness for the prosecution refuses to have his identity disclosed and wishes to give evidence in such a manner that he will not be seen or heard by the accused or his counsel, the prosecution may make an oral application to the court for the procedures in this section to apply. The court then shall hold an inquiry in camera, which means in private, to question the witness concerned in the absence of the accused and his counsel. And if the court is satisfied, the evidence of such witness shall be given in such manner that he would not be seen or heard by the accused or his counsel. Now, the court shall not allow any question by the accused or his counsel to any other witness that would lead to the identification of the witness who has given both the accused and his counsel the Section 265A of the CPC. Now next, Section 265B of the CPC. It provides that if the accused or any other person is required to be identified by the witness who gives his evidence in the manner provided in Section 265A, such identification may be made by the witness through an interpreter or other court officer. Lastly, in Section 265C of the CPC, it provides that notwithstanding any written law to the contrary, any report through any means on a protected witness shall not reveal or contain the particulars of the protected witness. Now, all these are in order to protect the identity of the witness and also for the protection that the witness does not come to any harm. Now, next, we look at expert witnesses' reports. Now, Section 399 of the CPC provides for the production of expert witnesses' reports. Now, in subsection 1, it provides that any document purporting to be a report under the hand of any of the persons mentioned in subsection 2 upon any person, matter or thing examined or analysed by him, or any document purporting to be a report shall be submitted to him for report may be given in evidence in any inquiry, trial or other proceeding under the CPC, unless that person or registrar shall be required to attend as a witness. So, if that person is not required to attend, he may just produce his report. Now, if the person is required to attend by the court or by the accused, in which the accused must give notice to the public prosecutor not less than 3 clear days before the trial. Now, provided always that in any case in which the public prosecutor intends to give evidence, any such report, he shall deliver a copy of it to the accused not less than 10 clear days before the commencement of the trial. The expert witness, if he comes to court, must give oral evidence and cannot tender his report, but may refer to it to refresh his memory. This was held in the case of Saw Tin Tek. Now, some issues arise in regards to the expert witness report. Firstly, if the prosecution has delivered their expert report 10 days before the trial commences, the accused was given notice for the expert to come to court but did not object when the expert is not called, and the report is then submitted. The issue here is whether the expert report is admissible. In the case of Muhammad B. Abdul Rahman, it was held that the expert's report is admissible as the accused has waived his right. Now, contrast this for the case of Cha Siu Kok and the case of Ong Ba Seng. The expert's report was not admissible as the prosecution had delivered the expert report 10 days and the accused was given notice that the expert was to come to court to give evidence. Now, another issue is after the prosecution has delivered the expert report 10 days before the trial commences, the prosecution can still call the chemist to give evidence. And this was provided in the case of Muhammad B. Hassan. Now, the prosecution can still call the chemist following the best evidence rule. Now, next, another issue is if a trial is reordered, does the prosecution have to re-serve a notice? Now, in the case of Oi Lian Chai, this was considered. Here, the prosecution gave a chemist report to the accused 10 days before the trial. and the accused did not give notice for the chemist to attend. Now, later on, a retrial was ordered. The prosecution did not give a chemist report before the retrial, as he relied on the chemist report tendered before the trial. The court held that a retrial is not a continuation of the previous trial. The prosecution must give a new chemist report, but did not do so. Therefore, the original chemist report was not admissible. Now, in cases of identity and weight of a drug, the court in Munasami and as well in Ku Hee Chang held that there is no need to prove the expertise of the chemist if it is only related to the identity and the weight of a drug. Now, in the case of Satyamurthy against penguasa or komandan of the Pusat Pemulihan Karangan Kaedah, it was held that there is no need to tender a medical report under Section 399, subsection 1 of the CPC, if a magistrate inquires whether the accused should be treated for a drug dependent. Next, does the expertise of the maker have to be proved in court? Now, as we discussed earlier, in the case of Munasami, it was held that there is no need to show the expertise of the chemist in drug cases when it regards to identity or weight. However, if it is in regards to handwriting, copyright or ballistics or other types of expertise, this must be proven in court. Now, we consider the case of Nolos Albert Raleigh Home. The Court of Appeal allowed the accused appeal against conviction for drug trafficking because the chemist gave oral evidence that the drug was homogenized before analysis, but her report stated it was homogenized during analysis. The federal court allowed the appeal of the prosecution and held that the chemist had clearly stated that the drug was homogenized before analysis as in the report. Now, next, in the case of Navin Raj Naidu Gunasegaran against public prosecutor. In the Court of Appeal, the appellants were convicted for drug trafficking under Section 39B of the Dangerous Drugs Act and appealed on the ground that although the prosecution had given the chemist report to the defense counsel more than 10 days as required under Section 399 of the CPC, and both the prosecution and the defense counsel had agreed during case management to dispense with the calling of the chemist, there was no written consent of the appellants as to the dispensation of the chemist. It was held that the Court of Appeal, allowing the appeals and setting aside the order of conviction and sentence of the High Court against both appellants and ordering a retrial before another High Court judge, that amongst others, that although a copy of the exhibit, the chemist report, was tendered to the defense counsel during case management, written consent of the appellants in respect of the dispensation is required as provided for in Section 172A and 172B of the CPC. Now let's consider the relationship between Section 399 of the CPC with the exception to the hearsay evidence in a criminal proceeding. Now, if a document is to be tendered into court is for the truth of its statement, it is caught by the hearsay rule and it is not admissible. And this was established in the case of DPP against Subramaniam. So the hearsay rule is basically an out-of-court statement which is tendered in court for the truth of its statement, and the maker of the statement is not called. Now, the exceptions is that if the document is tendered under one of the exceptions to hearsay, for instance under res gestae, or to show the mental state of the maker and not for the truth of its contents, for instance under section 6, section 32, section 34 or section 73A of the Evidence Act, then the document will become admissible and not caught under the hearsay rule. Now, after considering this, let us consider whether the chemist's report is caught by the hearsay rule. Now, a chemist's report is made by the chemist, and the chemist's report is a document. Now, if it is tendered for the truth, it will be caught by the hearsay rule, as we know, and it is therefore inadmissible following the case of DPP against Subramaniam. However, Section 399 of the CPC provides that the prosecution must give the chemist's report to the defense at least 10 days before the trial for it to be admissible if the chemist is not coming to give evidence. Therefore, Section 399 of the CPC is an exception to the hearsay rule, and the chemist's report will be admissible if the requirements under Section 399 is satisfied. Right, let's look at some ancillary provision. Firstly, the view of place, the place where the trial will be conducted. Now, in section 417, subsection 1, subsection C of the CPC, the High Court may transfer the case if a view of the place is required. Now, in the case of Lee Ah Pua, a view of the place is allowed for permanent features but not for temporary features. So, view of the place is the view of the where the crime was conducted, or where the crime took place, or where the evidence is. So in the case of Harbans Singh, there was no sketch plan and only the magistrate and the prosecution viewed the place but not the defense. So therefore a retrial was ordered. Secondly, lastly in the case of Chong Ah Chai, the cement mixer could only be viewed at its location because of its size. It could not be brought into court. So the court held that it could only be viewed at the location. Next, we look at addresses and submissions to court. Now, the opening address is always done by the prosecution. However, an opening address is not mandatory for cases in the subordinates court. However, in section 174A of the CPC, it provides that opening address is mandatory in the High Court, and this is read with section 179 subsection 1 of the CPC. What about the defense case? In section 174 subsection B of the CPC, it provides that the defense may open its own case, and the defense may sum up at the end of the defense case as well, if the defense decides to adduce evidence. Now, the prosecution will then have a right of reply only if the defense gives evidence, and this is provided for in section 174 subsection C of the CPC. But in the High Court, the prosecution has a right to reply whether or not the defense gives evidence, and this is provided in section 182 of the CPC. Now, what about a submission of no case to answer? So a submission of no case to answer is when the defense considers or submits that the prosecution has not made out a prima facie case. Now, the Criminal Procedure Code is silent on the requirements or or on whether the submission of no case to answer is allowed. However, in practice, a submission of no case to answer is conducted and is allowed, and this was held in the cases of Mahinder Singh and the case of Ong Poon Seng. Now, as well, in the case of Chong Bu Si, the court may not allow a submission of no case to answer if the prosecution's case is a strong one. Now, contrast this with the case of Lee Kwan Woo. The accused was charged for drug trafficking under Section 39B of the Dangerous Drugs Act 1952. Now, at the end of the prosecution's case, the trial judge refused to allow the defence's application to make a submission of no case to answer and immediately called the defense. Now, the accused remained silent and was then convicted. On appeal, the Court of Appeal also dismissed the appeal, and following the Federal Court's decision in Chong Bu Si, where a trial judge could call for the defense if the prosecution has made out a prima facie case. Now, the accused appealed on the ground that the accused was not given a fair trial as provided for under Article 5, subsection 1 of the Federal Constitution. Now, the Federal Constitution did not follow Chong Bu Si and allowed his appeal, and held that at the end of the prosecution's case, the judge should invite the defense whether it wishes to make a submission of no case to answer. Then the judge will decide whether the prosecution has made out a prima facie case. Now, whether or not the defense can make another submission after the defense case was considered in the case of Loh Tim Phat. Now, if the defense has made a submission of no case to answer at the end of the prosecution's case, it is not allowed to make another submission at the end of the defense case. Now, next we look at section 259 subsection 1 of the CPC. If a witness is absent or for any other reasonable cause, the court may order in writing to adjourn the case and may, by warrant, remand the accused if in custody. Now, in section 176 subsection 2 subsection O of the CPC, the date and grounds must be recorded. Also, the practice direction 1/2011, the adjournment is not allowed unless agreed by both parties. Also, a practice direction 2 of 2011 provides, amongst others, that the court has discretion to allow an adjournment, and the hearing dates fixed by the court are prohibited from adjournment unless both parties agree. Also, we look at practice direction 1/2019. Firstly, an adjournment by the court. A judge or sessions court judge or magistrate, registrar or senior assistant registrar should plan his vacation or attendance in a course and his replacement if required. The new date should be informed to all parties in advance. Next, an adjournment on application by any other party. An application for adjournment should be made early so that the new date of the case can be agreed by the parties. If the hearing date has to be adjourned due to reasons which cannot be avoided, for example, the judge is sick, an immediate family member of the judge is sick or has died, the case should be heard by a replacement judge on the fixed date or an adjournment date by the original judge. Now let's look at some cases on adjournment. Firstly, in the case of Tan Fu Su, here the magistrate refused to postpone the case when the defense witness was absent. The court held that latitude should be given to an accused to defend his case and to call his witnesses. Now, reasonable cause is a term of art, and there is no definite ruling which can be laid down, and it depends on the circumstances of each case. In this case, the circumstances warranted the adjournment. Now, We also look in the case of Lau Yong Ping. The prosecution witness had to attend a High Court case. This was a reasonable cause. Also in the case of Muhammad Akram, the magistrate refused to allow an adjournment when a medical certificate was produced. It was held that an adjournment should be allowed and a retrial was ordered. In the case of Lee Fuk Sam, the application by the appellant for a fourth adjournment was not allowed. And also in the case of HLS Pereira and the case of Karuma, if investigation is complete, the magistrate should postpone the case and not to make a discharge not amounting to acquittal. Contrast this with the case of Tan Kim San. The court held if the investigation is incomplete, the magistrate should discharge not amounting to acquittal and not postpone the case. Also in the case of Mota bin Abdul Latif, on revision, the High Court ordered an early hearing as there had been two postponements. Lastly, in the case of Kamura Zaman bin Mahmud, V.T. Singham said that in the interest of justice, counsel for the accused should assist the court to proceed with the trial fixed for hearing until its conclusion, unless the adjournment is necessary if there was reasonable cause. Now moving on, we go to compoundable offences. Now the meaning of compoundable offences are when the victim and the offender may agree to settle out of court and the rules of contract apply. Now in section 260 of the CPC, it provides that the offences punishable under the Penal Code described in the first two columns of Part A may, when no prosecution for such offence is actually pending, be compounded by the person mentioned in the third column of Part A, or when a prosecution for such offence is actually pending, be compounded by the person with the consent of the court before which the case is pending. The offences punishable under the Penal Code described in Part B may, with the consent of the court before which the case is pending, be compounded by the person to whom the hurt has been caused. Now, when any offence is compoundable under this section, the abetment of the offence or an attempt to commit the offence may be compounded in like manner. Who would otherwise be competent to compound an offence under this section is not competent to contract. Any person competent to contract on his behalf may then compound the offence. Now, the composition of an offence under this section shall have the effect of an acquittal of the accused. And it is crucial to note that no offence under the Penal Code which is not mentioned in this section can be compoundable. Now, let's look at some cases on compoundable offences. Firstly, in the case of Azhar Che Will, the court held that any compoundable offence is exercisable by the victim of the offence or by any person competent to contract on his behalf. In this case, the court allowed the application of the parents to compound the offence for causing grievous hurt under Section 325 of the Penal Code. Secondly, in the case of Ri Chang Cheng Ho, on revision, the court held that the prosecution has to apply to court to compound the offence and inform the court that the parties have reached the settlement. Thirdly, in the case of Daud bin Kalam, the court held that only offences stated in Section 260 may be compounded. Next, we look at alteration of judgment. This is provided in Section 278 of the CPC. It provides that no court other than the High Court can alter or review this judgment except for a clerical error. Now, in the case of Heng Yu Nam, Once a judgment is perfected, it cannot be altered. Secondly, in the case of Vun A Shun, after an oral judgment is given, a magistrate may give the written grounds when the appellant appeals. And lastly, in the case of Ui Sing Lim, a High Court judge cannot recall his judgment after 2.5 months has passed. So the cases here establish that once a judgment is made, it cannot then be altered or changed in any way, except by a High Court judge under Section 278 of the CPC. Now next we move on to instances where there is a change in the judge. Let's say a magistrate is transferred to another court. Now in Section 261 of the CPC, it states that whenever any magistrate, after having heard and recorded the whole or any part of the evidence in a trial, ceases to exercise jurisdiction in it, the succeeding magistrate may act on the evidence recorded, or act on the evidence partly recorded by his predecessor and partly recorded by himself, or resummon witnesses and recommence the trial de novo. Trial de novo means to start the trial anew. This is provided that in any trial, the accused may, when the second magistrate commences his proceedings, demand that the witnesses or any of them be summoned and reheard. The High Court may, whenever there be an appeal or not, set aside any conviction that was had on evidence not wholly recorded by the magistrate before whom the conviction was had, if that court is of opinion that the accused has been materially prejudiced by the change of the judge, and then it may order a new trial. So let's look at some cases where the trial judge has been replaced or has been transferred. Now, in the case of Chelia, if the trial de novo is selected, meaning a new trial is selected by the new judge, the accused may demand any witness to be reheard under the proviso to Section 261 of the CPC. Also, in the case of Tia Wah Chong, the court held that it is better for a new judge to hear the case ab initio, meaning to hear the case from the beginning, instead of just carrying on from where the previous judge has left off. Lastly, in the case of Padmanathan against public prosecutor, the appellant here was charged under Section 409 and Section 471 of the Penal Code. Now, after 3 prosecution witnesses had been called, the Session Court judge was replaced by a new Session Court judge. Now, when the appellant requested for the previous judge to continue, there was no explanation why the previous judge did not continue. At the end of the trial, the appellant was convicted on the former charge, but acquitted on the latter charge. The appellant then appealed on the ground that the provisions of Section 261 of the CPC were not complied with, and this had prejudiced the appellant. The High Court allowed the appeal and held that Section 261 only applies if the previous judge ceases to have jurisdiction. In this case, there was no record whether the appellant had made the application for the previous judge to continue, and there was no explanation as to the outcome of the application. Now, the court also held that a succeeding judge would not be able to see the demeanor of the witnesses that has already given evidence. Therefore, since the procedure under Section 261 was not complied with, his conviction was not safe, as it prejudiced his rights to have a fair trial. Now, what if a trial judge is transferred to become a DPP or federal counsel and continues to hear the case? Now, in the case of Kula Singham, the court held that a magistrate who is transferred to be a federal counsel or DPP may complete a part heard case. However, in this case, since a large number of witnesses have been called and exhibits have been produced and there was a prima facie case, the trial judge ordered to be continued. Also, we look at the case of O Keng Seng. Here, Justice Ajaib Singh did not follow Kula Singham and said that if the magistrate is transferred to become a DPP, there should be a trial de novo by a new magistrate. This was followed in the case of Haji Ibrahim B. Wahab. Next, we look at the case of Muhammad Amin B. Abdullah. Here, the magistrate was transferred as a DPP. However, he continued to hear the case. The High Court held that the magistrate should be transferred back to the The High Court held that the magistrate should be transferred back to the judiciary to continue to hear the case. Now, if the magistrate is transferred as a federal counsel, he can still continue to hear the case. And this was held in the case of Goh Chui Guan. Now, therefore, we can conclude that whether or not a new trial should be held before a new magistrate, if a trial judge is transferred to become a DPP, it all depends on the facts of the case and also on whether there is a prejudice to the accused. Now, we have to note here that a part heard case in the High Court is similar to those in the subordinates court, and this is provided in section 18, subsection 2 and subsection 3 of the Courts of Judicature Act 1964. So this is similar to section 261 of the CPC, which we have just discussed. Now let's look at some cases here. In the case of Muhammad John bin Puteh, the trial judge discharged and acquitted the accused for drug trafficking. On appeal, the Supreme Court ordered the defense to be called. Meanwhile, the trial judge retired and was replaced with a new judge. The Supreme Court held that there should be a trial de novo, a new trial. Also, in the case of Lai Weng Kiat, here the trial judge of the appellant for murder was conducted by 3 different judges at 3 different times. The first 2 judges had heard the testimonies of 17 out of 18 prosecution witnesses. The last judge, who heard the last prosecution witness, ruled that the prosecution had made out a prima facie case. Now, the appellant applied for the case to be heard de novo, but the judge dismissed the application, stating that the appellant was allowed to recall any witnesses for the prosecution if he wishes to do so. However, the appellant decided not to recall any of them, and after hearing the defense, the judge convicted the appellant. The decision of the High Court was affirmed by the Court of Appeal. The appellant then appealed to the Federal Court on the grounds that the judge did not hold a trial de novo, and this prejudiced the appellant. Now, when it went to the Federal Court held, dismissing the accused's appeal and affirming the convictions and sentences, that firstly, where the demeanor and credibility of the witnesses who had given evidence earlier are crucial, it becomes an issue. The succeeding magistrate or judge has to hear the case de novo or recall the relevant witnesses to ensure that the succeeding magistrate or judge is able to assess personally the demeanor and credibility of the relevant witnesses. However, the succeeding magistrate or judge need not hear the case de novo and can act based on the cold hard print of the evidence, where the facts of the case are straightforward. and the credibility of the witnesses are not crucial. Secondly, in exercising its discretion under Section 261 of the CPC and Section 18, subsection 2 of the Courts of Judicature Act, the court had taken into consideration other factors, namely, firstly, whether it was more appropriate for the relevant witnesses to be heard rather than the whole case to be heard de novo. B. The large number of witnesses already called and given evidence and the large number of exhibits already tendered. Another factor would be whether the facts of the case were straightforward and the ability of the witnesses to recall events may have diminished with lapse of time. It would be unnecessarily prolong the trial and increase the expense, and it would cause unnecessary hardship to the prosecution and the witnesses. Thirdly, the application for the case to be heard de novo was only made 7 years after the commission of the offences. Under these circumstances, after a lapse of 7 years, the ability of the witnesses are diminished, and the ability to recall all the witnesses after 7 years would also cause unnecessary hardship to the prosecution in relocating those witnesses, as well as it would be unfair to those witnesses to be recalled. It would be also unnecessarily prolonging the trial and increasing the expenses. Now, the fourth decision that the court held was that the prosecution case rested entirely on circumstantial evidence. Now, since the credibility of the prosecution witnesses was not an issue, the judge could rely on the cold, hard print of the evidence of the material witnesses and decide the case accordingly. There was no necessity for the case to be heard de novo by him. Therefore, the appellant had not been materially prejudiced by the failure of the judge to hear the case de novo. Now, lastly, we look at the autrefois convict or acquit, meaning that instances where the accused is tried again for the same offence. Now, Article 7, subsection 2 of the Federal Constitution provides that a person who has been acquitted or convicted of an offence shall not be tried again for the same offence unless the conviction or acquittal has been quashed and a retrial has been ordered. This is the principle of double jeopardy, which a person cannot be subjected to under law. Also, in Section 302 of the CPC, it provides that a person convicted or acquitted of an offence by a court of a competent jurisdiction shall not be tried again for the same offence. Alright class, that's all for this chapter on summary trial procedures. I will see you in the next class. Thank you.